Can bankruptcy help your struggling business keep its doors open? Keep in mind that filing for bankruptcy can help a struggling business survive and even thrive. Find out how the legal process works and understand how to position your comatose company for a rosier post-bankruptcy phase. Remember that the liquidation option you choose, Chapter 7, 11, or 13, will depend upon the company's structure, assets, products and services, and amount of income available to fund a repayment plan. Welcome back, folks, to another edition of Sweetie Kiwi. How are you doing today? I'm doing fantastic. If you are doing as great as I am, go grab a cup of coffee or tea or vodka. Now let's roll. Today I want to have a conversation around the issue of bankruptcy and whether or not bankruptcy can help your struggling business keep its doors open. Let's first talk about the continuing your business, the factors you need to consider. Now, you'll want to consider several things before deciding whether or not it makes sense for you to continue or close down your business. Here are a few things you want to think about. Is the business making money? Now, you started your business in the first place to make a profit, right? So if your business is consistently losing money, closing up shop could be the right option. However, think about it. If you own a profitable company that's just facing hard times due to temporary factors such as the economy, we might have a recession, we might have a global health pandemic, it might make sense to stay occupational and to stay operational rather and weather the storm. What I'm trying to say here is that you want to keep things as operational as possible, including occupational safety, right? To make sure that if this is just a temporary event that the company is going through, weather the storm. Nonetheless, it's important also to be realistic about remaining open, right? A lot of entrepreneurs that I've talked to tend to remain optimistic, and often they will funnel money into a venture long after it's time to pull the plug. So that's number one. If the business is making money, you might want to think about whether it makes sense to file for bankruptcy. Second thing, are the business assets worth more than its liabilities? So you got to go back to the company's balance sheet. The balance sheet is also called the statement of financial position or statement of financial condition. This is the financial statement that allows you to see the financial worth of the company, also called the equity. So to find the equity, you have to subtract the liabilities from the assets. Now, assets stands for what the company owns, and liability stands for what the company owes. Okay, so if the business assets are worth more than its liabilities, then the company might have a chance, especially if the company is still making money. Then in that scenario, it might be worth saving. So you can reorganize your debt in bankruptcy, or eliminate it if you're a sole proprietor, might be just what's needed to keep the business afloat. Now, remember though, if the solutions offered by bankruptcy aren't feasible, you can always close the business by liquidating the property and pay off the business debt outside of bankruptcy, unless you would like to choose the Chapter 7 bankruptcy clause, right? You can choose a trustee to do it for you in a transparent manner. Either way, you want to be sure that you're considering the potential downfalls of a bankruptcy. I'll talk about that later on, but you want to think about that before you move forward. In most cases, you'll save a lot of cash and generate more funds for creditors if you close it that way. Now, on the other hand, if the business is severely upside down, meaning its liabilities are way above its assets, you likely already know that it might be time to cut your losses. Third factor to consider here, are you personally liable for business debt? Now, if you're personally on the hook for the obligations of your company, then it might be more beneficial for you to keep it running without taking on more debt, at least while you negotiate with creditors, right? Because even if you file for bankruptcy, you are on the hook also. So you're losing both ways. You're losing not only personally, but also professionally in terms of your business. So closing down the business might leave creditors with no other option but to go after your personal assets if the business does not have enough assets to cover its obligations. Another common approach is for the business owner to file an individual Chapter 7 bankruptcy and wipe out the personal guarantee. And I'll talk about that later on. Okay, so the three factors to consider whether you want to continue your business or discontinue it are: is the business making money? Are the business assets worth more than its liabilities? And are you personally liable for the business debt? I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Q. We're also having a conversation around whether or not bankruptcy can help your struggling business keep its doors open. If you love the clarity and the quality of the content so far, please consider subscribing to our channel and turn on the notification bell so that we can we can dispatch beautiful gems, beautiful shows to you every single day, rain or shine. You want to share this content, you want to like and comment below if you are interested in the conversation we're having now. Now, what type of bankruptcy should you file? This is a $1 million question. The answer essentially depends on the structure of the business organization, as well as the values of the business assets. Now, let me break it down. So you have, let's say, the sole proprietor and Chapter 13. If you are a sole proprietor, let's talk about what's interesting for you when it comes to Chapter 13 bankruptcy. Only individuals can file a Chapter 13 bankruptcy case. So if your business is a partnership, corporation, or LLC, you cannot file Chapter 13 on its behalf. LLC stands for Limited Liability Company. If you are a sole proprietor, you can include both personal and business debt in your Chapter 13 bankruptcy, just like you can in a Chapter 7 bankruptcy. So a Chapter 13 bankruptcy might be your best option if the sole proprietorship has income coming in, right? So you might be able to keep the business going while paying a lesser amount on both personal and business obligations that are non-priority unsecured debt. For instance, utility payments, personal loans, and credit card bills. Now, having said that, you might run into a problem if your sole proprietorship requires you to keep a lot of goods, products, or expensive equipment on hand. Although Chapter 13 bankruptcy allows you to keep your property, you still must be able to protect it with the bankruptcy exemption, and most exemptions won't cover significant business assets. Now, you might want to double check with your attorney, and so that you can get the best info in the area where you live. By the way, let me just, if I haven't said that already, a disclaimer here: we're not providing legal advice. We're not providing any kind of legal advice. We're not lawyers. We've done research. We have researched the topic. We are just providing to you general information. This show is educational. We're trying to shed light on an important topic. Everybody's situation is different, so I would strongly advise you to contact a legal expert, someone who understands the subtleties of business bankruptcy and can help you further. You can hear this show to have a better idea of what's going on, but when it comes to this defending your own business, it's always better to think about reaching out to an expert. All right, so what I'm trying to say here is that because many business owners are tight on cash, keeping all the property that you might need is not feasible if you don't have enough coming in to pay a hefty monthly payment. So what I'm trying to say is Chapter 13 bankruptcy, you can still be good if you are able to make minimum payments based upon the payment plan that was agreed upon with your creditors. Let's talk now about the sole proprietorship and Chapter 7 bankruptcy. Now, although filing a Chapter 7 bankruptcy rarely works to a business owner's advantage, this bankruptcy type might help you keep your business open if you are a sole proprietor who provides a specific service. For instance, you are an accountant, you are a fitness trainer, you are a coach, a personal coach, you are a freelance writer. The exhaustive list of activities that qualified under Chapter 7 bankruptcy can be seen on the internet. Just browse it, just search for it, and you'll find it. This type of bankruptcy can be effective because the bankruptcy trustee cannot sell your ability to perform a service, right? So you're not selling a product. You are selling your mind. You're selling your expertise. They can't take that away from you. So here's how it works. A sole proprietor is responsible for both personal and business debts. So when you file for Chapter 7 bankruptcy, what you do is you will include in the documents filed with the court all debts, all financial obligations, and that bankruptcy Chapter 7 will erase both types. Now, you can also use bankruptcy exemptions to protect the relatively minor asset associated with your business. Exemptions are rarely sufficient to cover businesses that require a lot of products, equipment, or goods. As a result, it is a wonderful option for sole proprietors with little or no business asset because it will wipe out the business debt and allow the owner to continue providing the service, thereby keeping the business running. Right? So if you have more business debt than consumer debt, you'll be able to file a business bankruptcy and avoid the means test, which means that your income wouldn't prevent you from qualifying for a Chapter 7 discharge. Okay? We will definitely talk about this. We'll have an entire issue dedicated to Chapter 7 to go a little deeper. Just know quickly here, in a nutshell, it's better if you are a service provider than if you are selling something. If you're selling tangible goods, Chapter 7 may not be for you if you sell tangible goods. But if you sell intangibles, let's say you sell expertise, such as you're a freelance writer, you are an accountant, and you're a personal coach, you might want to consider Chapter 7 if you believe this could help your struggling company keep its doors open. Let's talk now about all businesses in Chapter 11 bankruptcy. Now, partnerships, corporations, and LLC must file a Chapter 11 bankruptcy instead of Chapter 13 bankruptcy to reorganize debts and stay in business. Now, remember that a sole proprietor can also file a Chapter 11 bankruptcy as well as if they want that. Now, Chapter 11 bankruptcy is similar to Chapter 13 bankruptcy in that the business keeps its assets and pays creditors through a repayment plan that has been approved by the court. Nonetheless, it is usually a lot more complicated when compared to Chapter 13 bankruptcy because the business must file continuing operating reports and the plan must be approved by creditors. Right? Now, Chapter 11, it's also prohibitively expensive for most small businesses. So when you hear, for instance, a publicly traded company filing for bankruptcy, that's typically Chapter 11 because they can afford it, right? So this is the in a nutshell the type of bankruptcy you should file. I'll be right back right after this. Don't go anywhere. Welcome back, folks, to another edition of Sweetie Kiwi. We're actually having a conversation today around the issue of business bankruptcy and can bankruptcy help your lethargic business keep its doors open? Now, there are other things to know. Let me just say this. Why businesses rarely file for Chapter 7 bankruptcy? Now, in the vast majority of cases, a Chapter 7 bankruptcy will close the business because there is no way to protect property owned by a separate legal entity like a corporation or a limited liability company, LLC. So the court-appointed trustee generally will sell the business assets, will whatever money he or she gets will pay the creditors and shut the business down. So but that's not the only reason why Chapter 7 bankruptcy isn't regularly used by businesses. Here are a few other things you need to know. Most owners can wind down a business without help, thereby avoiding the added cost of bankruptcy attorney, right? If you have to pay an attorney, there's extra money, and in a moment where you want to save, and you also have filing fees. So most owners, they can just wind down the whole thing themselves. An owner can often get a better price for the assets than the bankruptcy trustee. So if you put a partnership into Chapter 7 bankruptcy, the personal asset of the partners are at risk. Filing for bankruptcy gives creditors an instant platform in which to air disputes, and this consequently opens the door to litigation, right? And this litigation will involve things such as fraud, an action to pierce the corporate veil, a partnership dispute. A corporate veil is the lawsuit seeking to hold someone with an ownership interest personally liable for the debt of the company. That's just the little lingo here. So because of these reasons and more, it's just important to seriously consider whether the risks of filing for a particular bankruptcy type, Chapter 7 for instance, outweigh the benefits of closing the business through bankruptcy All right. Now, what happens if you are forced into bankruptcy? Because sometimes you are forced into bankruptcy. If you're a business owner, you have no choice. You just have to file for bankruptcy. In most cases, though, bankruptcy is entered into voluntarily. In some situations, creditors might force a debtor into bankruptcy involuntarily. So, involuntary cases are highly unusual, but they do exist. So, a creditor or a group of creditors might use this process primarily to force a company into a business bankruptcy. It's rarely used against an individual in a consumer bankruptcy because meeting the prerequisites necessary to file an involuntary bankruptcy isn't easy to do. It's just the court's requirement for that process. The process is very long. The checklist is very long. So most cases will require several creditors to get together and agree to file against the debtor. If accomplished, the court appoints a bankruptcy trustee to take over all aspects of the business, sell the assets, get the cash, and distribute the proceeds to the creditors. Now, this might be, you might be thinking, well, wow, this could be helpful if many creditors will just come together and agree to initiate their own collection actions. But it is not that easy. Why? In reality, if creditors do this, they retain the ability to grasp a larger share of the business assets. Because once in bankruptcy, a creditor is more likely to have to share proceeds with other creditors or take a smaller portion, or in some cases get nothing at all. So they're not winning actually here. So it is important to understand that a creditor might not be able to keep funds collected shortly before bankruptcy, especially if it's considered a preference claim favoring one bankruptcy creditor over another. And courts have been very, very strict in implementing or in executing the preference claims in the last 5 years. So many creditors are willing to take the risk and return the funds if necessary. Now, so the involuntary process begins in the same manner as a voluntary action. Official bankruptcy forms get filed with the court. Okay, this is basically the end of today's conversation. I will see you next time, but before I go, let me just quickly give you the recap of today's conversation. I spoke to you about continuing your business and considering factors to do so. Is the business making money? Are the business assets worth more than its liabilities? Are you personally liable for business debt? And then I talked about what type of bankruptcy you should file. And I said the sole proprietor in Chapter 13 bankruptcy. We also talked about the sole proprietor in Chapter 7 bankruptcy. And then I spoke about all businesses in Chapter 11 bankruptcy. And other things to know. Why businesses rarely file for Chapter 7 bankruptcy. And when you're forced into bankruptcy, what to do. I will see you next time. But until then, remember, stay marvelous.